Good evening, everybody, and welcome to today's webinar brought to you by the NBPS Alumni, Mentorship and Alumni Welfare Committee. And today we are honored to be joined by our esteemed lawyer and advocate of the High Court, Madam Grace, who is also an alumni of NBPS, and she's also part of our team, and we're honored to have her come on board. So I won't be saying so much. I'll be allowing her to give her insights, and we ask that you also engage with us on the comment section. So feel free to engage with us. I'm bringing her on board now. Hey Grace, karibu
Hi
sana.
Keshi. Hi Keshi.
Karibu sana.
Asante.
Yeah, so I'll be going off now. Feel free. The comment section, I know it will be ablaze with questions. I also know you received some questions. So just start by introducing yourself and then you can flow. And I'll take a back seat now. Go
Okay,
ahead.
thank you very much. Thank you very much,
You're welcome.
Keshi. Good evening, everyone. Uh, Welcome to this evening's brief discussion on various pertinent issues touching our lives every day. I'll be highlighting a few aspects of the children's law, marriage, divorce, succession, and sexual offenses in relation to minors. I'll start with the children cases. A child, as defined by the law, a child is a person who has not attained the age of 18 years. And the law that governs children, is contained under Article 53 of the Constitution and the Children's Act, the new Children's Act. And it states that every child has a right to receive parental care and protection, which includes equal responsibility of the father and mother to provide for their children, regardless of whether they are married or not. Uh, Many questions that are coming in were in relation to custody issues, where parents have separated. What happens to the children that they have, and among the concern was whether the father can have custody of children or tender age of minors? And my answer is yes, we are equal under the law. The father and the mother have equal responsibility and equal rights over their children. So yes, it is not in the best interest of children to be alienated from either parent. So the best approach in terms of custody is joint custody or co-parenting, as we know it on social media. We call it co-parenting. That is the best approach to the issue of custody. Uh, so it has to be smooth. Parties have to agree. They have to put their differences aside and agree when either parent will be spending time with their children, all in the best interest of those children. Yes, if so, my answer is yes, a father can be granted custody. And actually, uh, increasingly, nowadays we are seeing cases of fathers being granted custody and the mother being told to be paying child maintenance to the father. That is not strange. It is in our constitution and it is the right way forward for Kenya. And people are asking, may need to know how to, in case you have a child maintenance issue, how do you go about it? There are organizations that assist. They provide legal aid. That is an organization like FIDA or the Federation of Women Lawyers, the National Legal Aid Program, or the Christian Lawyers Fellowship. You can even approach an individual lawyer to help you. Most lawyers, uh, or at least those I know, offer pro bono services in children matters. And the considerations that uh, that may be considered when making a child maintenance order is the financial needs of each parent, the income, earning capacity, the circumstances of the child, whether they have special needs, religion, custom, or practices, or liability of other persons to support the child, for example, step parents, and other issues that may arise, special circumstances of the case, all, but the primary consideration is the best interest. Best interest is best interest of that child, not of either parent, but of the child. We have a new act in place in terms of the children. Uh, the highlights of that act is that that act raises the age of criminal liability from 8 years, which has been the norm previously, to 12 years. Age of criminal liability is when a person or a child can be considered to be able to differentiate between right and wrong. So, this act raises it from 8 years to 12 years, meaning a child under the age of 12 years cannot be charged in court, cannot be held to be criminally liable or responsible for any even murder, anything. As long as that child is below the age of 12, they cannot be charged with any criminal offense. And children under the age of 12 years, if they commit, if they do something wrong, they are usually treated through counseling, rehabilitation, and other diverted systems. This new act prioritizes family-based care as opposed to institutions, meaning that we shall have fewer children's homes and adoption being made smooth and easier to ensure that children grow up in a family setup as opposed to institutions. It addresses online abuse and child trafficking, radicalization. The previous act did not address how to go about cyberbullying of children or preying of these children online. It establishes also a child welfare fund to be funded through the exchequer, and also it mandates the county government to establish child welfare schemes and child care facilities. Another important aspect of that act is that all children who come in conflict with the law are are provided with free legal aid. They are provided with an advocate to work with them through the journey, and kinship adoption has been included in the law. Now we can have kinship adoption, which is adopting a person, a child who you are related to. That was not previously in the law. Uh, we go to divorce in case the marriage did not work. Okay, we highlight marriage first. Uh, there's only one law that governs marriage, that is the Marriage Act 2014. And this act governs customary marriages, Hindu, Islamic, statutory marriages, and a hint of presumption of marriage or kamiste. Although kamiste is not a marriage that is recognized under the law, but long period of cohabitation can presume you have to tender evidence to prove that you are married. You look for people, a person of sound mind to come and say what they think about your relationship. But these other marriages, you don't need to prove anything. Uh, all these marriages must be registered, including customary marriage. That is what the law provides. You must register your customary marriage. And among all these marriages, the Hindu and the customary marriages accommodate polygamy. That means if you want to be in a polygamous marriage, you have to be in a system that accommodates polygamy. It is legal in Kenya, but it depends on the type of marriage you contract. If you contract a statutory marriage is strictly monogamous, so it does not accommodate polygamy. But a customary marriage, as long as the first wife you marry her under customary law, subsequent wives you can marry them. You can marry subsequent wives under the same system. But you cannot combine. You cannot combine customary and statutory. Hindu marriages and Islamic marriages, of course, they are governed by Sharia law. Hindu marriages Islamic marriages are accommodate up to four wives. So yes, they allow polygamy. And all these marriages they have to be registered under the law, under the Marriage Act, by the Registrar of Marriages at Sharia House or the Attorney General offices across the country. That being the case, all these marriages, there is only one form of divorce. There is no to say that customary marriage will be dissolved by customary divorce. No, all marriages will only the court has jurisdiction, whether it's the Qadhi's court or the ordinary court, to dissolve a marriage. So you have to file for divorce in court. There is no divorce out of court, and there is no divorce by consent in Kenya, the way we see in movies where people say, I'm not going to sign divorce papers. There are no papers that people sign in Kenya. It is you present a petition in court, a divorce petition, then you give the respondent, the other party, an opportunity to respond to that petition. They can also elect to file a counter petition against you. The grounds for divorce are in the Marriage Act: cruelty, adultery, desertion, insanity, irreconcilable differences. One can rely on either of those grounds to file their divorce, and then you'll tender evidence in court, and then the court will grant the divorce. Whether if you have convinced the court that the marriage has irreconcilably broken down, only the court can grant a divorce. So there is no divorce by consent. There is nothing like signing of divorce papers. And also touching a bit on family law, the issue of succession. Succession only applies when a person has died. That law comes into effect on the death of a person. So you cannot apply the law of succession in your lifetime. It will only apply to your property or to your affairs upon your demise. Two types of succession. You can leave a will. If you don't leave a will, people can decide how to distribute your property. Remember, a married daughter can inherit from their father. Children are treated equally regardless of whether or not they are married or whether they are female or male. So we see in court, we see children coming to claim that daughters cannot inherit because they are married or because they are girls. The law is very clear. There can never be discrimination on any basis, whether gender, marital status. We are all equal. So advice is that distribution of an estate of a deceased person should be done in an equitable way. Not necessarily equal, but equitable. We come to the last issue. This session, I hope I hope people will be interactive. We come to the main issue that people are asking about the in sexual offenses. What happens when both parties, both the victim and the accused person, the perpetrator, are both minors? If they are both minors, they are below the age of 18 years up to 12. Remember, we said the age of criminal liability is 12 years. So we are talking of people between the age of 12 to 18 years. If they are caught up in this, how do you go about it? If they are both minors, how do you go about it? Like the case of Romeo and Juliet. In case they are both minors and there was consent in brackets between the two, they'll be diverted from the court system. They'll be taken through counseling or rehabilitation. They will not be punished because both of them are victims or villains, mostly victims. There should never be discrimination. But uh, when one of them is a minor and the other is an adult, the adult will have to face the consequences, even if it was consensual, so to speak. As long as one of the parties to that relationship is a minor, they will have to suffer the consequences of the Sexual Offences Act, which is defilement. Uh, the age of consent in Kenya, where you can agree, you can be able to be declared to be someone who can give consent, capacity to give consent in a relationship is 18. That is in Kenya. I have looked at this comparative. I have done a comparative study on this, and I have noted that some countries this age varies. For example, surprisingly, Nigeria, the age of consent in Nigeria is 11 years. Angola is 12 years. Japan is 13 years. Bahrain is 21 years. South Korea and Nepal, 21 years. Interestingly, Pakistan, Iran, Sudan, Afghanistan, Saudi Arabia, Yemen, United Arab Emirates, Libya, Oman, Kuwait, Qatar, and the Maldives, there is no age of consent. Actually, the requirement is that you must be married, meaning that if you engage before marriage, it is illegal. And if you get married at 12, 20, 35, 40, that is your age of consent. The requirement is that you must be married. Uh, marriage, marriage is the union between man and woman. Remember, Kenya, we forbid polyandry. Uh, a woman cannot have more than one spouse, but a man can. Polygamy is legal, but polyandry is not even in the law. It has not even been talked about in the law. There is no offense. I mean, we have not even the drafters of the law did not even anticipate or think about it. So it is it is not in the law at all, but certainly it is not allowed. But I'm yet to see anybody. It is the law is silent on it. I'm yet to see any woman being arraigned in court for polyandry or marrying more than one, having more than one spouse. Bigamy, bigamy will apply where you marry under a system that only tolerates monogamy and then you enter into polygamy. For example, you contract a marriage under a statutory marriage, which only allows monogamy, and then you go ahead and marry another spouse under customary law or under the same act, bigamy, before divorcing the first spouse. And I'm using the term spouse so it applies to both male and female, husband and wife. Uh, if you commit the offense of bigamy, of course it's a criminal offense, but I have tried to look for case law or anybody who has ever been charged with bigamy. Perhaps that one I throw it to the viewer or the listener of this podcast. Tell me whether you have ever seen anybody or you know person who is in serving a jail term or whatever for polygamy. Keshi, now I'll open up the panel for questions. I don't know whether we'll be seeing chats coming through or people will be asking live.
Yeah, so if you just click on the top right of your screen, you'll see some of the questions that have been coming in. So there's a question from Bigland Express. I've pinned it there. Can you see it? I've pinned it on the screen. So he's asking what defines insanity when it comes to divorce.
Okay. Actually, thank you. This is Bigland Express. Insanity. Insanity is lack of mental capacity. You are not able to distinguish between space and matter. Only a registered psychiatrist can declare somebody to be insane. Actually, insanity is a ground for divorce. If you enter into marriage with a spouse and then they become uh, mental mentally incapacitated and there is no hope for recovery, you can petition. That is a ground to petition for divorce. But this declaration of mental insanity has to be made by a psychiatrist. Is that clear?
Yeah, it's clear for me. So Bigland, probably you can chat on the box whether she's answered your question. I don't know if Grace, you have some questions from the private messages that people shared with you. Probably other people had similar questions. You can highlight maybe one or two that people asked
Yes.
you in private.
Okay. Actually, my presentation has been centered around the questions that were being asked. Of course, I can't be so specific. I don't want to. They were asked in private. I can't answer them publicly, but I have just generally answered them on the issue of divorce. People are asking whether you can just walk away or there's any other way for divorce apart from going to court, and the answer is no. There's only the court has jurisdiction to declare to annul or dissolve.
All right.
Yes,
Thank you.
even if you get married under customary law, you
Mhm,
cannot divorce under customary.
mhm. Okay, great. So I've pinned a question from Victor Washira. He's asking under what law in the normal Christian marriage, that is, I've done a church wedding, is that a monogamy marriage? As a man, I can add another wife.
Okay, most church marriages or church wedding is usually celebration of a statutory marriage. You have to undergo a statutory marriage first, and then you go to church to church wedding is like a celebration. So most people who are wedding in church, most of them, majority of them, are under statutory marriage, which only accommodates monogamy. So if you've done a church wedding, it cannot allow, you cannot add another wife before divorcing the one that you married under that system, that Christian marriage that you're talking about. What you can do, what how you can go about this to beat this, there is always a solution. There is no problem without a solution. You can agree and divorce, and then marry her again under customary.
Okay, so there's a question here from Betty Waidera. She's asking, so if you're married in church, then a husband decided to take a second wife, can you sue for bigamy?
Mm, you can report bigamy is a criminal offense, so you can report to the police station, and then they can be arrested and arraigned in court. What you can do, if you're not okay with it, you file for divorce on grounds of adultery. Unauliza inheritance ni right ama ni favor? Uh, it is both a right. It is both a right and a favor. It is a favor to the extent that a person a person who has property during a lifetime of a person, they can decide who to leave their property to. You can decide to write a will and give everything to church and deny your children anything. So it is a favor to that extent. But if somebody dies without writing a will, their children will inherit as of right.
All right, next question is, what is the process of divorce?
Okay. The first, if you want to file for divorce, you visit an advocate's office, and then they prepare a petition for dissolution of marriage. You file it in court, you're given a number, and then you serve your spouse. You give them 8 days to respond. If they don't respond, you just go back to court and say you did not respond, and keeping quiet is considered to be admission. So you're given a date to go and present your case, and you can request to be allowed to present your case in camera. Most of the divorce cases proceed in camera because people value their privacy. So you appear in court and you give your testimony, and then the court, based on that testimony, will give a judgment on whether or not that marriage can be salvaged or it has broken down.
Okay, the
Uh,
next question
Betty is
is,
asking why we are skipping. Have we skipped?
no, no, no. I think probably I'm seeing all the questions here, so
Okay.
his question has been answered. So God is asking, can't the will be challenged?
A will can be challenged. A will can be challenged in terms of if it is not a valid will. A valid will is a will that has been written when the testator or the person who was writing it was not of sound mind. Perhaps it was their last days towards their death. They were not probably of sound mind. They could not recollect all their properties or who their true beneficiaries are. You can challenge it on that ground. Or it was not signed by two independent witnesses. It is ambiguous. Uh, Also, if you're left out in a will, you can file for provision if you are dependent on that person. For example, this person is the one who was paying your fee. You are in the middle of a school term, they have written a will, and they have left you out. you can make an application to court for, it's called an application for provision of dependency. So most
Okay.
of these issues you
Oh,
have to visit an advocate. I'm just highlighting.
mm, go ahead.
The cost of divorce in Kenya minus lawyers charges. Okay, that one is assessed in, costs are assessed as you incur them. Huh? For example, there'll be filing fee, uh, service process server's fee. You need to serve that person through a process server. So process server's fees, and then legal fees. Minus legal fees, if you don't take into account legal fees, other costs, they are called disbursements, should range between 5 to probably 10,000, not more than 10,000. And then you add legal fees. Legal fees, I cannot tell you now. There's a schedule that we use, and each case is charged on its own peculiar circumstances. We don't, legal fees is not uh, the same. Each case on its own peculiar circumstances. Is a schedule under the Advocates Law Society of Kenya Advocates Remuneration Order. That one you have to go to an advocate. They explain to you how much your specific case will be. You don't have a blanket charge for all the cases. Na
Okay.
kuna
Um,
David anasema kuna
mhm.
hii law ya ukikaa na girl child kwa nyumba for more than 6 months inakuwa a marriage. Can you clarify on what basis? Okay, this one is not recognized under the law. Hii ya presumption ama ya presumption come with stay. But if you cohabit with a person for a long time, the period is not specified. You do things together, you uh, acquire joint property. Anybody being asked how you live, they'll say like husband and wife. It can be presumed to be a marriage, especially in succession cases. Long period of cohabitation, you look at the intention of the parties. Even if they did not solemnize under any system, what was the intention? It's telling you each case on its own peculiar circumstances. Uh, Gad Mwangi is also asking, does a kid born out of wedlock have a right to inherit? Can one challenge a will that is not equitable? Okay. Okay, children are children. The law of succession does not discriminate at children, whether born in wedlock or not. All of them are treated equally. Actually, there was before 2001, when the Old Children's Act came into effect, there was a discrimination on children, and this was challenged by FIDA, and all children are treated equally, even for purposes of succession, inheritance, they are treated equally. So they'll inherit if all the children are inheriting 1 acre, regardless of whether they were born in wedlock, as long as it is a child of that person, of the deceased, they have a right to inherit equally. And can you challenge a will that is not equitable? Uh, Equitability is relevant, is relative, sorry, is relative because a person, there's something called testamentary freedom. You have a person during your lifetime, you have the freedom to leave your property to whomever you please. As long as the will meets the requirements of a valid will, you can leave everything to even one child. As long as it is a valid will that is tested by two witnesses, you wrote it in sound mind, you identified the specific legacies, uh, but you can uh, maybe perhaps you may need to add to give me the specific problem that you need to solve when you ask that question, or whether can one challenge a will that is not equitable. That is where now you need to sit down with a lawyer to give them more facts of the case.
I'm not
Mm,
sure. I'm not sure if you addressed that one. It's from Daddy Productions, and is it no? Sorry, not that one. Just a moment. Yeah, he asked what is the cost of divorce minus lawyers' charges. I don't think you answered that one.
oh yeah, I answered. I said between 5 to 10. That is disbursements only,
Okay.
without lawyer charges. It should not, maybe give a budget for 15,000 without lawyers fees. By the way, there is no requirement in Kenya that you must be represented by an advocate. You can choose to represent yourself even in the most complex of cases.
Hmm.
That way you'll not incur legal fees.
Okay. Guys, keep engaging us in the comment section. Just know we are live on YouTube. That will
There's
be
this
our
question, Eshi,
yeah. Yes,
there's
go
another
ahead.
question asking that he had asked also, is it necessary in the case of an affidavit but no certificate? I'm assuming he's asking whether a divorce is necessary if you have an affidavit. If you saw an affidavit of marriage but you don't have a marriage certificate, whether it is necessary to go through the divorce court. But yeah, I said you must, if you have an affidavit, especially in customary law, where nothing is issued under customary law, there is nothing, there's no certificate that is issued. So most people swear an affidavit, and that affidavit you present it to somewhere like NHIF, and the spouse anaingishwa kwa card. Imagine you have to file for divorce if you want to remove that spouse. Otherwise, they'll always be appearing in your records.
Okay, there's a question from Jacqueline Gure. Can a divorced or separated partner be a beneficiary in succession, whether the marriage was customary, statutory, or amicable stay?
A separated partner, yes. Uh, the law of succession, the law of succession is very peculiar in that it does not. It is a standalone act. It does not concern itself with other statutes. Other laws don't apply, meaning that the Marriage Act does not apply to the law of succession. So, this is where separated spouses come in to inherit, and they actually are allowed to come in. As long as there was no divorce, you just separated. The Act states uh, your beneficiary is your wife, your former wife or husband. That means if you only separated, you did not divorce, you fall under the category of former spouse, who are included among the beneficiaries of a deceased person. So the law of succession, Jacqueline, does not concern itself with validity of marriage. So yes, a separated partner is a beneficiary in succession, whether customary, whether statutory, or come with stay, as long as she can prove that she was a spouse and there was no divorce, she will come in.
All right, thank you, Grace. There's a question here from Big Blood Express. The scenario of countries that have no age limit for girls to get married, but they are married, it is legal. What happens when they visit a country like Kenya? She's 14, he's 30, but legally married.
Mm, okay, yeah, I mentioned some countries. and mostly Arab countries, Pakistan, Iran, Sudan, Afghanistan, Saudi Arabia, they don't have an age limit, an age of consent. As the requirement is as long as they are married. So that exposes small children to uh, underage marriage, or they are called early marriages. So as long as you're married, there's no age of consent. If they come to Kenya, there are certain law. You see, the law of Kenya applies to Kenyan citizens, and if they are married, they produce a marriage certificate. Okay, that one we have to do more research on it, because I would assume that if we saw a 12-year-old girl working with a 58-year-old man, as a country, we have an obligation to intervene. We should.
Thank you. So, advice on legal land purchasing procedure. That's from David Mushems.
Okay. Uh, it is a long procedure, not specifically, but generally, if you want to buy land, the first step is due diligence. You do your due diligence, you do search, you obtain a green card. If it is free for you go to the ground, you see whether there are any persons occupying it, engage a surveyor to confirm the acreage. You negotiate purchase price, uh, have an agreement, a land sale agreement drawn by an advocate. Don't do things huko nje na Kikuyu. We see people writing to small notes na amenunua 50 acres, ameandika na Kikuyu in kidogo, kakaratasi kadogo. So the best agreement is an agreement made by an advocate, so that it has all the clauses that protect both of you and that are binding. Most of the disputes emanate from our poorly drafted agreements, ambiguous, or agreements zenye hazieleweki. So you enter into an agreement, and then you pay a deposit of the purchase price. Then you appear before the land control board. You make an application before the land control board. You obtain a consent. You also obtain a spousal consent. Uh, After that, you do a transfer. When you're signing the transfer, the vendor should be able to supply you with all the completion documents, the original title, kitambulisho, pin na picha, and all that. And then at that point you pay the balance of the purchase price. Mnaenda kujiprocesia title. The purchaser usually pays stamp duty. Is the responsibility of the purchaser to pay stamp duty and all other registration of title fees. Anachukua title. It should be straightforward, whether it is a leasehold property or a freehold. Uh, so what else? A succession procedure where there's no will. What is the process? The first step is to obtain a death certificate. Inatokanga certificate of death, sorry. Inatokanga after 30 days. Exactly 30 days after that person passed on, you should be able to obtain it, and then you appear before the area chief mwenye alikuwa anajua that deceased person, anakuandikia barua ya identification of the rightful beneficiaries. Armed with those two, and then you have a search. You do a search at the land registry to confirm that those parcels of land are in the name of the deceased person. Armed with that, you appear before an advocate. You process the succession forms. You also need to have agreed on who is the proposed administrator of the estate. There can be a maximum of 4 administrators in one estate, and then you file for succession, you file the forms, uh, then they are gazetted. After 30 days, if there is no objection, the administrator is appointed, and then you come back after 6 months to confirm the grant, or you can even come back earlier before 6 months if you have agreed. You confirm you file an application for confirmation of grant, and then hiyo siku ndio mnaappear in court, all of you. Nowadays people appear online, you don't need to travel to court. So if some of you are in America, Australia, wherever, you don't need to come physically back to Kenya because of succession. There is online signature online, so it is a bit easier. Explain what decree nisi means. A decree nisi is a divorce decree. It is issued immediately. It is the judgment of the court. It is issued immediately when the court is delivering the judgment that the marriage has irretrievably broken down. It issues a decree nisi, and then after 60 days or 30 days, or whichever amount of time the court will declare, you confirm that actually you have not been able. You're given a period of time to go and decide whether you really need to make this decree absolute. uh, that period of time you can reconsider the divorce. If you don't reconsider, you go back to court, you convert the decree nisi to a decree absolute, and that is the end of the marriage.
Daddy had some more questions. Maybe you can put them in one answer. So he
Okay.
asks, and the titles can be changed before succession is processed in the
Mm-mm.
case of wrong relatives or if they hold the documents.
Title deed cannot no okay. When a person dies, no person can intermeddle with the estate of a deceased person. It is a criminal offense that can earn you some jail time. So it is illegal to intermeddle with the estate of the deceased or to try and change titles. So no, unless you I don't know which method you will use, but there is nothing that can be processed in a title deed where the proprietor is deceased without succession having been done, and the court confirming that actually the succession documents emanate from court and they are genuine. So you're not able to change. Okay. There is River Road, but legally, no, you cannot be able to change titles before you file succession.
Okay, the last question I see here is from Charlene. She's asking, what if you can't afford to get a legal fee? To get the legal fee, how can I get help?
Okay. I had mentioned there are some organizations that offer free legal services, free legal aid to people who cannot be able to afford. That is the National Legal Aid Program, NALEP. It is in every county. FIDA, or the Federation of Women Lawyers, Christian Lawyers Fellowship, or you can even approach an individual lawyer and request and explain your circumstances that you're not able to afford. Many lawyers can assist. You don't need to be shut out from achieving justice just because you don't have money. Money should not stand between you and justice. Be brave. Just in fact, even these senior lawyers uh, are very approach. They offer pro bono very quickly and very well. Every law firm has a pro bono policy.
Right. I don't see any other question. If you have any final questions, you can
Thank you,
share them.
Dr. B.
Yeah, we
Uh,
only have 10 more minutes to go. So if you have any pressing question, but Grace, also you can share how people can reach you for more personalized consultation and where they can find you as we wait for a few more questions. But a lot of comments coming in from our viewers and most are alumni. Wanasema asante sana. So just let us know how we can reach you for private consultations and where you are
okay.
based.
Okay, thank you very much for listening to me. Uh, it is an honor to be able to impart what I know to you. And as I said, nobody should stand between you and justice or whatever you want to achieve. Just approach an advocate. For me, I'm based in Nyahururu, and the law firm Wangechi Wangari and Company Advocates. We are situated at a cooperative bank, same building that has cooperative bank at the back side, first floor. We are also based in Olkalau at Data House, first floor, next to on top of Kenya Women. You can reach me by via my telephone number. My telephone number is 0720 809 592. Uh, Mostly, I prefer you a WhatsApp message. I may not be able to answer all the calls. So for ease of access, if you have a legal issue, WhatsApp me anytime. I'll be able to respond. So kwa hayo machache, asanteni sana Keshi for organizing this, and see you next time.
Before you go, Victor, you've been answered. She's based in Nyahururu and Olkalau. God says asante sana Wakili for that really good advice. So yes, thank you everybody for joining us and engaging with us. This session will be pinned on our YouTube page. I continue to encourage you to follow us on social media, on our social media platforms, so that you can also grow our platforms and our online presence. Um, Maybe Grace, you can answer this last question from Stephen Washira. He's asking whether Charles Ayenda alitolewa kwa land
Eh,
registrar.
eh. We had a demonstration. I don't know whether Keshi you saw us on TV. Tukia blog Vuvuzela.
Yes.
Early this year, we had a demonstration, a protest in town. We were protesting the removal. We wanted to remove the land registrar who had become so oppressive, and we succeeded. He was taken to Kisii, and surprisingly, last week, Kisii advocates also took to the streets. You can see that is in the media. Whether then they were tear gassed, I don't know whether they were shot.
Okay. So someone is
On a
saying
light
if you can repeat.
note,
Yeah. Sorry. Go ahead. Sorry, I thought you had finished.
it's okay, I have finished. Or I can repeat my number
Yeah.
for Dati Productions. That is 0720 809 592. 0720 809 592. And thank you, everybody. You made the session very interesting. I know law can be so boring, but you made it interesting.
Thank you so much. And looking forward to this edition. The next one will be on the 31st of July. We have a social emotional learning expert and a psychologist who will be taking us through different aspects. So prepare your minds to learn and grow. Grace, asante sana for your outpouring of love, knowledge. Tumesoma sana. And thank you so much for being willing just to share and to engage with us and being part of this series. God bless you so much and good night, everybody.
God bless you
Asante
too.
sana. Pia nyinyi mbarikiwe. Bye.
Bye.